All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and bless this honorable court.
You seated? Madam Clerk, if you'll call the case.
Case number SC 20250370, The New York Times Company v. Kai Spears. This is a certified question from the United States District Court for the Northern District of Alabama. Arguing for the appellant, the Honorable Chad Bowman. And arguing for the appellee, the Honorable Matt Glover.
Mr. Bowman, are you ready?
Good morning, and may it please the court. Chad Bowman on behalf of the New York Times Company. Both certified questions today from the Northern District of Alabama relate to the interpretation of the same statute, Alabama's nearly century-old Reporter Shield Law, and that statute's language provides the answers to both certified questions. Alabama was one of the first states in the nation to pass a law that created a privilege for news reporting sources, created for the general benefit of the public by encouraging sources to come forward with information to the press. The first certified question basically asks whether the statute applies to a newspaper that is published both in print and online, a print edition and an online edition. The statute itself says that it applies to anyone connected or employed with any newspaper, end quote.
I'm sorry, why do we need to reach this question? It was published online and published in print, so why don't we just go to the second question?
I would be happy to do so, Your Honor. I don't believe there's a dispute that the New York Times is in fact a newspaper, but that question was certified to the court, so I would be happy to address any questions the court has about that question.
We don't want to hear it. Move on.
Thank you, Your Honor. The second question relates to the scope of the privilege. The statute protects, quote, the sources of any information procured or obtained, end quote, by the journalist for the newspaper. And so the question rises, what does the source mean? When the statute was enacted, it was enacted, as Price, the 11th Circuit decision, which interpreted the statute about 20 years ago, noted, to safeguard and protect the professional confidence of newspapers and newspapermen. Was from the relatively scant legislative history. Source clearly means the identity of the person providing the information, the facially identifiable information like the source's phone number and address. But for the plain language to be given effect,
Sources means people.
it can be something. It could be a document as well. In this case, because the New York Times is asserting the sources is a confidential source. I don't think off the top of my head of a confidential document, but the sources would be the confidential people who provide information to the news media.
And all you're claiming here is protection under the Act for people.
That is correct. And documents that would identify people. There are a handful of documents in this case that were produced in discovery in redacted form, redacting phone numbers, the places of meeting with the sources, photographs that would be identifiable of the sources, and notes that might identify those sources. So that the documents that would identify the two individuals here who were confidential sources.
Counselor, in regard to the documents, I noticed that one of the questions that was asked in regard to documents, in regard to source A, I believe, is what were the documents? And the answer was documents related to the case. And then what documents related to the case? And then there was an objection. And I think the answer was, I'm not sure I can answer that without narrowing the universe. Now, how does that answer to that question, how does that somehow violate or lead to the discovery of the identity of the source?
Is this court considered in the Henry Pugh case which involved the confidential informant issue. The prosecution in that case objected to questions that could lead to the identity of the source, including whether someone was or was not the source. Because in this case, the describing what the document was would essentially point the finger at who the source could be, or at least certainly narrow down to a small universe of who the source could be. And so that becomes the context-dependent answer to the question. A source's employer might not be personally identifying, if you describe in a news story, an employee of Walmart provided this information. But if the answer to the question of the employer is someone in the bakery department of the Renfros, that might be source identifying. It's a much smaller universe of people. Whether someone is an eyewitness to an Alabama game, saying they're an eyewitness might not be source identifying, but a very small meeting saying that someone is an eyewitness to that meeting narrows the list down to a relatively small number of people. And so that's sort of the context-dependent nature of answering as many questions as you can in discovery, providing as much information as possible, but honoring the commitment that was made to protect the identity of those sources.
You mentioned the confidential informant privilege, and you've compared the privilege here to that privilege, but aren't there some more serious constitutional protections afforded to criminal defendants that come into play that make it not quite so comparable to the CI privilege?
I agree. If we're talking about the scope, what I think is useful in the Pew case, it's not that that's a qualified privilege. You're right. There are greater constitutional protections, and here there's the constitutional basis for the reporter's privilege, and there's an absolute protection that the Alabama legislature chose to enact. In the Pew case, the court deferred to the district court's decision about whether the privilege applied. And then on the question of once it applied, what does it protect? It said it protects against questions that would point toward the identity of the source. It's a very sort of a common sense approach. If you are protecting a source, it can't just be social security number, cell phone number, and name. It has to be other details that would inevitably or reasonably point to the identification of that source.
Those are two very different standards that you just mentioned, though, right? Inevitably point to the source. I think the other side even conceded that the phone numbers and email addresses inevitably would point to the sources here, but reasonably pointed. Well, there's no language in the statute about that, right? It just says sources.
The statute says sources, Your Honor, and we think that the proper result and the result taken by courts around the country is information that would reasonably identify the source. The Louisiana Supreme Court considered this precise issue in a case we discussed in our brief, Henry Burns. And in that case, there was a source that was described, I think, as a courthouse source. And the question was put to the reporter, identify whether that source was an employee of the clerk's office. And ultimately, that issue went up to the Louisiana Supreme Court. And the Louisiana Supreme Court said the statute, to give effect to the source protection, quote, includes within its protective scope not only the actual name of a confidential source of information, but any disclosure of information such as place of employment that would tend to identify him. Otherwise, through a series of indirect questions, the identity of the informant could be obtained without the need to ask for the informant's name directly, resulting in the subversion of the reporter's privilege. And I agree, this court has the power to decide whether it's reasonably, whether it's likely. We think that the appropriate test and the test that most courts around the country use is whether the questions would reasonably lead to the identification of the source.
You mentioned various courts across the nation. So does our statute, are there other jurisdictions that have similar statutes to the one we have here in Alabama?
There are. We cite, I believe, Ohio. We cite California. We cite Nevada. Statutes, we cite Florida. Most of the statutes don't give a prescriptive list. In fact, I'm not aware of any statute that gives a prescriptive list of what information is protected. They say the source is protected. and it's left to courts to reasonably determine on the facts in front of those courts whether those questions go to information that would reasonably identify the source.
Normally, the proponent of the privilege has the burden to establish that it applies, correct?
Correct.
Was there any effort to ask the judge here, Judge Axon, to look at things in camera or to explain to her why this particular piece of evidence would reasonably tend to identify somebody? Was that ever suggested by you? Or did you provide an affidavit to the judge to explain why the evidence that they were asking for would reasonably identify the person?
For the relatively narrow set of documents that were withheld that are in front of Judge Jackson, the answer is no. As I mentioned, the only documents that were withheld and that are subject to the still pending motion to compel in the Northern District are phone numbers from the reporter's call records, the meeting logistics that would reveal where the reporter met source A, photographs that contain visual cues about source A, or the information from the handwritten notes. Those are not the kind of things that were subject to, a request for an in-camera review. The assertions of
Your
privilege.
objections, though, at deposition were far broader than that. You objected to any questions, off-the-record discussions you might have had, right?
That's
Instructed
correct,
your
Your Honor.
witness not to answer. You can only instruct your witness not to answer based on privilege, right?
That's correct, Your Honor.
Have you waived these objections and let that witness be deposed?
Those were third-party witnesses, Your Honor, who were deposed pursuant to a subpoena issued out of the Southern District of New York. The objections were made, and the plaintiff's motion to compel brought in the Northern District of Alabama over those third-party depositions was dismissed, that motion to compel. So the plaintiffs haven't moved to compel that testimony in federal court in New York.
But you held these instructions. You still are asserting these instructions.
Yes, very similar to the Enri Pugh case, in which the Alabama Supreme Court said it was a proper objection for the prosecution not to let a witness answer whether he was or was not a confidential informant. If it's essentially it's a process of elimination. When there are a limited number of people who have information, knowing who isn't the source, knowing it's not proverbial Colonel Mustard or Miss Scarlet, narrows the field of who is the source.
But that's a
Goes back
different.
to your-
That's a different. I'm sorry. That's a different question. Are you the confidential informant? Than was asked here, and I think the question, and several witnesses were asked this question: did you speak to this person on the record? And I think the answer in most cases was I did not. Then, did you speak to this person off the record? And at that point, they were instructed not to answer. So, how does that, in and of itself, I mean, it doesn't seem like that just protects a source. Nobody's asking, were you the source?
Right.
So, how does elaborate on that a little bit, please?
Sure, Your Honor. The witnesses who were asked, did you speak with person A? The witnesses were careful, for the most part, to say, I didn't speak with witness A on the record. Or, because they didn't want, if that witness A happened to be, a confidential source, they couldn't honestly answer that question by saying, no, we only talked off the record. And so what the witnesses in those New York depositions said was whether they spoke with someone on or off the record. If a question was broad, did you ever speak, which would encompass on or off the record, there was an objection and instruction only to answer on the record. It was essentially the same issue as Pew, same process of elimination. There's a limited number of people because the New York Times has produced a significant amount of discovery in this case. For example, the plaintiff knows roughly when the reporter met with source A, roughly where the reporter met with source A. And so providing sort of who wasn't source A starts to very narrowly point to individuals.
I understand the connect your dots argument here, but I guess something you mentioned earlier. Who decides? How do you? I mean, does your client just get to say, "Oh no, that could identify the source"? Trust me. Is that it? Or is there some process? As Justice Cook said, I think the person asserting the privilege has the burden to prove that it exists. So speak to that if you could.
That's a good question. I appreciate asking that. And frankly, that's why we have trial judges. There's no question the plaintiff could have argued that certain objections at the depositions were improper and moved to compel. The plaintiff didn't do that in the Southern District of New York. The plaintiff has not challenged the scope specifically of the document redactions. But certainly those issues are adjudicated based on the facts in front of the judge. There's representations that those phone numbers that were redacted would lead to the identity of a source. Those photographs would. And I don't believe that I don't believe that issue is beyond what a district court judge can decide.
So basically, the judge at some point is the one that, I mean, you'll have a duty to, in some fashion, in camera, inspection, but in some fashion, you'll have a duty to present that to the judge, and the judge is the one that makes the call as to whether the privilege applies.
It's certainly true that this court provides the standard. The judge applies the standard. And whether that requires in-camera review is going to vary by circumstance, right? Same thing for an attorney-client objection. Sometimes a privilege log is sufficient. Most of the time, a privilege log is sufficient. There may be rare cases where...
So even if we answer your question yes, aren't you still back to what Justice McCool said? Even if we say, okay, any and all, you still are going to have some objection. You're going to have a trial court basically make a determination whether this information is going to lead to the discovery of who the informant is. So how does answering yes help you? And I know you're out of time, and I apologize.
Do you want him to answer?
If you don't mind, I'm sorry, I didn't want to.
Yeah, I'll answer very quickly, and I appreciate the indulgence. I think that what would be helpful for the trial court is the standard of what is being protected. Is it what would reasonably identify a confidential source, like every other, most other courts do? We're not aware of any court that doesn't do some protection like that.
Thank you very much.
Thank you.
Thank you, Mr. Bowman. Mr. Glover?
Madam Chief Justice, may it please the court, if I may just for a second go through some important facts here, because as you are aware, the plaintiff in this case, Kai Spears, in fact does bear the burden of proof to establish at a minimum negligence, but most importantly to establish the state of mind of the defendant. And the at issue time period here is about 10:31 a.m. till it went to online publication at 7:10 that night. When the article came out, it stated 6 times as an unequivocal fact that Kai Spears was in the car with a murder weapon as it was transported to the scene. 11 paragraphs in, the New York Times finally pointed out that that information was based upon one anonymous source. We now know that the anonymous source equivocated on how he or she knew that. We also know that there was a second source, not cited in the article, that informed the Times that it was likely wrong. Despite the information, the Times stood by its publication.
I thought the second source, it was after the article came out that the second source said I was likely wrong.
There is a message exchange, justice-wise, between Billy Witz, the reporter, and another editor that does, in fact, post-date the article, that states as a fact that there was another source that told the Times that they were likely wrong. But we know from the privilege log that source B was communicated with before the article came out. We've been shielded from asking any questions about what that particular source B, even though not cited in the article, informed Billy Witz. So our focus has to be on what did the defendant know? Did it know the source was false? Did it have reason to doubt the source was false? What did it do to corroborate what the source said? As a basic fundamental principle of the Times, they use anonymous sources as a policy, as a last resort, and that the source should have direct, firsthand knowledge.
You asked that question, I think, at one point, and was the answer, was the privilege asserted?
Yes, Justice McCool. So the answer to the question was, yes, I understand the difference between firsthand knowledge and secondhand knowledge. Yes, that is a policy, but when that question was asked, which by the way is not source identifying, it is, did that person have firsthand knowledge? The New York Times, in its broad interpretation of the statute, says do not answer that question because that could lead to the discovery of who the source was.
So I'm hearing, I think what you're saying, there's no disagreement that certain information besides just name, serial number, social security number and address, there's some information that would still be protected from disclosure under the privilege. But I think the disagreement I'm hearing is over how much. So I guess my question is, could you speak to that? How far do we go?
We have to start with the common law. And at the common law, there was no privilege for a reporter to shield an anonymous source. When the statute came out in the 30s and then was amended in the 40s, it says the source of the information. Okay, that statute is in derogation of the common law, which means this court must interpret it in the strictly and narrowly, and if there's any doubt, to find the least change possible to affect what the common law was. And so in application, we have said, look, we're not entitled to know the identity of source A. We're entitled to know the identity of source B, because you didn't cite that person in the article. But then when you get to something like, did that person have firsthand knowledge? The statute doesn't allow the Times to say that is privileged. I
think I agree with you on that point. I really do. But didn't they throw in the briar patch? Aren't you better off that they won't let their witness even say whether they had firsthand knowledge? You get to the trial, they can't sword and shield you and suddenly do that at trial, right? So aren't you just better off if they don't tell you?
Well, Justice Cook, I may be better off, but I'm in the position where I don't know how detrimental the facts are.
Yeah.
Matter of fact, the Seventh Circuit has said a media outlet shouldn't be able to say that here are the facts that help our side, but then we're going to assert the privilege to shield from detrimental facts. Look, make no doubt about it. We intend to seek punitive damages, and that is premised on what the New York Times did or did not know. So as bad as I think it is at this moment for the New York Times, I believe that under the statute that I'm entitled to more, that Kai Spears is entitled to more, and I can't help but think that what we don't know is even more detrimental than what we do know.
So, Mr. Glover, if we answer the question, no, and we say that the Shield statute doesn't protect any and all information, does that really help you all that much? Because you're still going to have a dispute. We know there's certain things that you can't get, but what does any and all? Some? How does that help you, and why should we answer the question in the negative?
Well, Justice Sellers, I believe that we have to just take the statute at what it is, and that is the identity of the person. We take that to be the name of the person. Now, in all fairness, that's why we didn't ask for emails, phone numbers, address, because the reality is that information is not important to us. What is important to us is, who did you talk to? What did they tell you? The person who did tell you it was Kai Spears, what was their basis for believing that? Was it firsthand knowledge? Or was that just information that was passed along? Because if it's information that's just passed along, that's information that the judge and the jury needs to understand when evaluating the reliability of the information. Because it goes right to the fact that the Times has a policy that we're not supposed to do that. And so I think that if the Times believes that the term identity, the source, should be broader, I think those arguments are arguments that they should take up with the legislature. The legislature has demonstrated that it knows how to amend the statute. It did so in the 40s. This issue that the Times raises is really no different than what was raised in the Mike Price case that was decided 20 years ago. Cumberland Law School said there's an issue because of that decision and the statute about how far does this go. So for 20 years, that's been a known issue, and the legislature has not addressed it. And so we would ask that
What is your test for determining the scope. I mean, I think the New York Times is pretty clear, reasonably likely. Do you disagree with that articulation of a test? Because you've conceded, I think, it's not just the name that's protected, but also maybe the phone number and email addresses. Where's the line if we're called upon to articulate a test?
Well, I think that's, Your Honor, where the New York Times bears the burden. It's a privilege that they assert. It's not a
burden. What burden do they? What substantive standard must they cross to?
I think that they would have to demonstrate to the trial court that there is something about this information and what is being requested that would be identifying. Not that it may identify, but that it would be identifying. But
Mr. Glover, we're a court of nuances. You know that.
sure.
So reasonably, likely, probably, no doubt whatsoever that it would lend to identifying the source. I mean, there's got to be some sort of standard that we have to tell the trial court to look at.
Well, I think this, if the statute is in derogation of the common law, it needs to be the least possible. I mean, I do think that should be it, because the statute just says source. I don't think it's reasonable.
So highly likely to lead to the source?
I think an email would do that. I think an address would do that. I think a phone number would do that. I don't think someone just simply saying they have firsthand knowledge, or they lack firsthand knowledge, or that they're affiliated with the University of Alabama could do that. Otherwise, every single media outlet could take that position.
So should we just rephrase this question that's been presented to us? Because it sounds like you're not as comfortable with the question because it needs to be maybe much broader or more specific. We're allowed to do that, and we get these questions and we can reframe it. Is that what we should do? Because if we answer this negatively, I'm not so sure based on your argument today that really gets you the answer you want. That's going to have the court to compel these answers and that information.
I don't think it should be facially identifiable with the source. I think that's as far as it goes. And whether that's phone number, email, I think that's as far as it goes. From there, the defendant has the burden, in this case, the New York Times, to put that information to the trial judge to get some direction on as to whether or not firsthand knowledge would violate that somehow.
Okay, Mr. Glover, let me read you the sentence, the question. Does the SHIELD statute protect any and all information that could lead to the identification of the source? So what I hear, I think you saying is, instead of saying could lead, would say any and all information that would highly likely lead to the identification. I mean, do you see what I'm saying? We're trying to get how we weigh this, or how we tell the trial judge to weigh it.
And
Well-
we can also decide not to answer either question.
Well, that's definitely a possibility, and just a flat out no may be that answer. But Chief Justice Stewart, I think that the language that changes the letter of the statute the least is what the court should do. Could, possibly, that is not restrictive at all. That means anybody in Tuscaloosa. Anybody in the state of Alabama, anyone who graduated from the University of Alabama. That protects the New York Times, and it doesn't allow a victim of defamation to prosecute their case. So there has to be some type of, you can assert the privilege, it's your burden, but under Alabama law, unless it identifies the source, it is not protected.
Okay, Justice Sellers threw you a bone. He asked you, he told you, we can rewrite the question. I think Chief Justice Sellers, I was giving you a promotion. Chief Justice Stewart also was trying to help onto that. What would you like, if we were to rephrase the question, the certified question, what would you like it to say?
If the information sought is source identifying on its face, I think that is protected. I think that's as far as it goes. How that is worded, I don't know, but I don't think it should be any broader than that.
Let me ask this to follow up kind of with all of this. I mean, ultimately, is it whatever standard we set out there? Is it fact oriented? Is it going to have to be not necessarily the standard fluctuating, but is it going to be? So, you know, for instance, I mean, you can ask a question. For example, my source, you know, was your source a member of the state of Alabama judiciary? Okay. All right. That would seem to be narrowing it down, but it would be, you know, there's a lot of judges out there. All right. But then you say, did you meet with your source in his office in the city hall in Gordo, Alabama? All right. That kind of narrows it down to me and a couple other people. So is there some place in between, you know, where do we go with, where would you go with something like that, with a situation like that?
Well, keep in mind, Justice McCool, the scenario you're talking about is simply just the anonymous source that was cited in the newspaper.
Mm-hmm.
That is not what the New York Times is asking for. They're not just asking you about the anonymous source and where you met with the anonymous source. They're asking anybody you talk to. Because anybody you talk to off the record could lead to the discovery of the one person you did talk to who is your anonymous source. So under your circumstance, saying like somebody's with Alabama, I don't think that narrows the universe. I think if you say a circuit judge, that doesn't narrow the universe in terms of this statute when it has to be restrictive. But if you said the judge who sits in Carrollton, and he's in Carrollton when he's not in Fayette or in Vernon, that would likely identify the source. So at some point, it is going to be factually based that the judge has to consider.
So at some point, you're saying there would be a proper objection that should be upheld based on privilege, depending on the particular question and the factual situation, correct?
It would have to be very narrow, and it would have to be limited to just the source that you cited in the newspaper. If it's not a source cited in the newspaper, it is not protected under the statute. Only in this case is source A protected under the statute. And that's not what the Times is asking for. They're asking for a broad interpretation of the statute that goes well beyond source A.
I think you asked for your formulation of the test earlier was that anything that's not source identifying on its face. Okay, so does that play into that little hypothetical I gave you? Because that would not be source identifying on its face. You wouldn't be saying, was it Justice McCool or Judge Junkin or something like that? You would be saying, you know, where'd you meet with them? I mean, so help me with that a little bit.
Yeah, I think that at some point, you know, the person asserting the privilege has the burden. And they have the burden of the privilege to establish that what is being asked would be, under my suggestion, on its face, self-identifying.
So when they assert the privilege, is part of the privilege whether a conversation was on or off the record? And how do you even prove that without a judge somehow being involved in the whether it is or it isn't? 'Cause that's critical, right? I mean, if you talk to them on the record, it's a totally different case because they wouldn't be talking on the record and they wouldn't be anonymous. So.
Well, I think Justice Sellers, in your scenario, anytime that you talk off the record, okay, the fact that you talk off the record, unless you use that source in the article, it is not covered under the privilege. It wouldn't be. Even if that person is covered, though, whether they have firsthand knowledge is not on its face self-identifying. It's not. I guess there's a scenario out there were only one person that could possibly have witnessed something. That could be self-identifying, and that's where it may become factually based upon that particular case and the objection that is made by the defendant. But simply to say whether you have firsthand knowledge is self-identifying would not be applicable.
Mr. Glover, let's talk about what they said the actual evidence is that's been redacted here. The photographs that might have the person's face in it. Would you be able to take that photograph?
Well, I have not seen the
Identify
photograph.
person?
I haven't seen the photograph.
Well, they don't want you to see the photograph.
I know, which
But let's take their assertion that that photograph is a group of people and the source is one of those groups, those people. It would be very easy in today's world to go through and see who all those people are, unless it's, a picture of a football arena.
well, that could be, which is why I think under the statute, you have to find the most narrow construction, and that is just the identity of the source. You have to, from my
But there-
perspective,
let's say the photograph is just two people. I mean, maybe that goes back to, I think maybe Justice Sellers asked about in-camera review. I mean, is that what your position? That if we adopt a test like identify on its face, that would require the trial judge then to look at each piece of evidence to say, can I identify the source on the face from this document or picture? Is that what you're saying?
I think that is a scenario that could happen under your situation, where if you have a photograph that has two people in it, and in this case, the defendant has a legitimate objection that to produce that photograph would identify the source, then at that point it should be looked at by the trial court in camera. But again, that is not what is happening here. It's not limited to a photograph. They have taken this, as someone pointed out, they have taken this position in depositions about anyone that the reporter talked to off the record, whether they were with the police department or the university, whether they had firsthand knowledge or not. So there could be, Justice Stewart, some situations out there that would require that in camera. But it wouldn't be this broad protection that would just be, you got to take our word for it.
So is that ultimately then what you're saying is once we set the standard and say, then that's ultimately a question for the trial court to determine whether this particular assertion of the privilege meets that standard?
The standard should be, according to the statute, that it would only be applied to the anonymous source that was cited in the newspaper.
Okay.
It would not be applicable under the statute to anyone other than the anonymous source. But in terms of the information that's requested, unless it is self-identifying of the anonymous source, then an objection would not be appropriate. If it was self-identifying, then an in-camera inspection, which has not been asked for by the New York Times, would be the appropriate way to address it. Because it's some...
Your time is up.
Thank you, Chief Justice.
Thank you.
Thank you.
Mr. Bowman?
Bowman, before you get started, I have a question. Can you tell us what your formulation of the standard would be? What are you asking us to say?
And also, if we need to rephrase the question, would you maybe help us that? Because I think it goes into exactly what you're saying.
Yes, Your Honor. I think that the standard can be phrased into the question. Does the SHIELD statute protect any and all information that could reasonably lead to the identification of a source whose identity is protected from compelled disclosure under Alabama's SHIELD statute?
So you would add
I would add reasonably, Your Honor. I wanted to make just two quick points. One, just to be clear, the New York Times had two confidential sources, has only asserted privilege over two confidential sources in this case. They didn't, the statute doesn't require that both sources be cited. The statute requires that information from both sources be included. That is the case here. The privilege assertions at the depositions are to protect a process of elimination for source A and source B. The other,
How far does that
I'm sorry.
how far does that extend though? I mean, theoretically, you could say any question, any answer to any question could lead to the source, because you eliminate this person and that person, and then I mean you could. Yeah, I mean, I guess I think we have on the one hand a recommendation that it's anything that's source identifying on its face, but where are we at on your side? I guess.
in the specifics of this case, there are a couple of categories of people that might have been the source, right? Was it law enforcement? Is it an eyewitness? And saying yes or no to those questions eliminate entire categories. And so it's significantly narrowing in that case.
But ultimately, that would be a question, once we give you a standard, that would be a question for the trial court to determine whether your side has reached the the test, has met the test for the privilege to be asserted. Is that correct?
Exactly, Your Honor. That's the application of the test to the specific facts
Okay.
of the case.
So the statute doesn't prevent Mr. Glover from doing lots of homework and figuring out who your source was, right?
Correct, Your Honor. The New York Times has not stopped.
If you get the camera that was on the strip and it shows who your client was talking to, and gets those pictures, that's perfectly fine under the statute, right?
The New York Times has not, correct, Your Honor. The New York Times has not objected to any question asked of any witness other than the New York Times reporters and journalists who are asserting the privilege.
And so the statute says that you shall not be compelled to disclose, and then there's some other words, the sources, right?
Correct, Your Honor.
So it's the disclosure by your client of the source that's the only thing that's protected.
Correct, Your Honor.
But what if, all right, following up on that, what if, I'm trying to get in my mind where this, where the standard is. So let's just say that, he's got a video of your reporter talking to the source or just a person. Okay. And in questioning, he says, okay, did you talk to this person? Okay. And you try to assert the privilege. You say, well, here's a video of you talking to this person. All right. Is that you? Can he answer?
Yes.
I mean,
Question about
yes.
the video, Your Honor.
You see where I'm headed? So tell me, how does, I'm confess I'm a little bit unclear on where to go with this,
I think it's context dependent, and it's question by question dependent. It's applying a standard to the facts. And I don't think this court has to think through every possible circumstance that the privilege could be asserted, or in a particular factual situation, what question might be source identifying. I think the court establishes a standard. And in that way, I do want to mention that, you know, the idea that,
Stop. So
yeah.
very briefly, Your Honor, the idea that the statute should be interpreted narrowly, I wanted to point the court to Ex parte United Service Stations, in which this court looked at the strong public policy underlying the statutory psychotherapist patient privilege and said, given the strength of that policy, other interests shouldn't easily outweigh it. The public policy in this state has long been to protect the ability of people to share information with the press for the benefit of the public. The amicus brief submitted by the Reporters Committee for Freedom of the Press, the Alabama Press Association, and others gives examples of the types of reporting, important reporting, that would not have been possible without confidential sources, whether it's pharmaceutical testing on inmates, misuse of taxpayer money, local retaliation, police retaliation against online critics.
Mr. Bowen, your time is up, but you
Thank you,
can
Your Honor.
finish your sentence as long as you don't keep giving us examples.
No more examples, Your Honor.
Okay.
My last sentence is all of that reporting depends on the ability of sources to trust that their identity will be protected. Thank you, Your Honor.
Thank you all very much. We appreciate the arguments today. We'll take this under submission.
All rise. Court is adjourned.